New details on Trump's $90 million bond are raising alarms. That big bond being posted at the 11th hour last week in the E. Jean Carroll case, giving Trump time to appeal that defamation verdict before he has to pay up. Trump's bond was underwritten by a branch of the company Chubb, one of the largest insurance firms in the world, and one that has a history with Trump. In 2018, Trump appointed Chubb's CEO, Evan Greenberg, to a White House Advisory Council on Trade Policy. Then in 2020, Greenberg served on a council of business leaders advising Trump on how to reopen the economy after the COVID pandemic.
My next guest is on the president's task force to reopen the economy, and he was on that call yesterday. He is Chubb Chairman and CEO Evan Greenberg.
The more we can have the ability to test, identify, isolate, while we practice social distancing. And, you know, we weren't telling the president anything that he doesn't already know.
All of this raising speculation that Trump may have called in a favor to secure that bond. Chubb also has provided Trump with insurance policies in the past, which came under scrutiny in his New York civil fraud case. New York Attorney General Letitia James alleging that in 2010, quote, Chubb sent an insurance appraiser to determine the worth of Trump's triplex penthouse apartment at Trump Tower. But Trump rushed the expert out before the assessor could take any measurements. Also of note, the terms of the bond agreement between Trump and Chubb have not been disclosed to the public. We don't know what assets Trump may have had to put up to secure that bond, or more importantly, if the bond was co-signed by someone else. Former FBI counsel Andrew Weissmann making this very point on The Beat on Friday.
And the issue is he going to be beholden to somebody? We already know that somehow he got a bond from Chubb. And, you know, I'm interested in knowing, did somebody, for instance, have to co-sign? Was there somebody there, some individual there who he's beholden to?
Joining me now is Neil Peterson, the owner of the New York-based surety bond agency, Peterson and Sons, and Christy Greenberg has stayed and is back with us. Christy, I wanted to start with you because from a legal standpoint, in criminal cases, for example, there's something called a nebia requirement, right? So if it's a case that involves drugs or maybe money laundering, et cetera, sometimes there is a requirement for a criminal defendant to have to show that the bond proceeds came from clean money, right? But we don't have that in this instance in a civil case. We don't have that for purposes of an appellate surety bond. So how concerned should anyone be, including the court perhaps, as to whether or not the terms of this bond need to be kind of transparent for everyone to know about?
Well, I think one thing I thought was interesting was today was the day when E. Jean Carroll's lawyers could have objected to the bond. They did not do so. And the court, has to still approve the bond. But usually there's not a lot of looking behind and trying to get transparency from the court. If you can get a bond from a reputable insurance company, then usually that's really the end of the inquiry. And at least for E. Jean Carroll, knowing that there is security there and that she's going to get paid if, as I suspect, she would be successful in her appeal is really the end of the inquiry. But for us, obviously, as the public, and with this individual being a candidate for president, it raises all kinds of questions. So, yes, you would love to know that there's going to be transparency. I just don't know that we'll get it from the courts here. There is one person who may have some insight into it, and that may be the independent monitor, Judge Jones. Remember, any time now under this new decision from Judge Engoron in the civil fraud case, any financial disclosures that need to be made to a third party, including lenders like Chubb, need prior approval from the independent monitor, need to be reviewed and approved before they can go out. So she may have some insight as to what kind of who it is, who the lenders are, if there are any, and what that looks like. So she may have some insight, but I don't know that will ever trickle down to the public.
Neil, put your bond hat on for us and kind of walk us through, A, whether or not there's much ado about nothing when it comes to this bond, and B, how much would somebody like Donald Trump have to put up to be able to get this bond in the first place, and what kind of collateral would you be looking for the balance of that judgment?
So in my professional opinion, I believe he had to put up liquid collateral a lot of different newspapers and other organizations are talking about using real estate as collateral. It's not traditionally done with a matter of this size. It's generally the surety has 10 days to pay the judgment. I believe in the bond that was filed, it has some sort of 30-day clause. 30 days is not sufficient time to liquidate real estate and, satisfy a judgment. If you had to liquidate real estate in 30 days, it would be at a fire sale and the price would be impossible to determine. Separately, there's other issues. If former President Donald Trump is reelected, can you perfect the indemnity agreement, which is the contract surety companies use to secure the bond against the sitting U.S. president? So that's one of the concerns. Surety companies are not very forward thinking and they're very risk averse. So it's not like someone's going to come in here and extend a lot of credit. And the asset base you would want for a client with a matter of this size to extend them credit would be several times what it's reported that former President Donald Trump is worth. So be looking for somebody worth 17 to 20 billion to really get them a lot of credit.
So Neil, I want to stick with you for a second then. Assuming when you say liquid assets, you're talking cash, right? Because cash is king. If Donald Trump doesn't have the ability to be able to give a reassurance to a bond surety that he has that, value to be able to satisfy making sure that that surety company gets what it's putting its own money up for at this point, would you then require somebody to co-sign on that bond?
That's always an option. I have a lot of clients that have an additional guarantor, or what we call as indemnitors. There's various matters where maybe you have one party that needs to obtain a bond and maybe another company is going to acquire that company. So they may have a vested interest in getting them a bond, or there could be other reasons, such as, someone has a vested interest in a person getting a bond and they could step up and guarantee it. So yes, that's a possibility.
And, Christy, Neil brings up a really important issue, which is you get somebody like Trump, he ends up back in the Oval for whatever reason, can't get him to maybe honor his obligations contractually that he has to do to federal insurance, which is the surety in this case for E. Jean Carroll. So what do you have to do if you can't sue a sitting president or even really, pursue anything civilly because he's a sitting president? Does the federal / Chubb just have to wait until he gets out of the Oval to be able to collect on any of this?
Right. I mean, that to me is the real conundrum for any insurance company, for any potential bond company that would be looking to secure a bond here, is that if he does become president and he stiffs them, the recourse is not going to may not come for a while. So it's a real risk to do. And I'm really, especially with someone, again, who's been found liable for committing financial fraud, and in particular, insurance fraud. So this seems like a real risk to me. Again, it seems as though he had a personal relationship with the CEO of Chubb, and maybe that came into it. I mean, it raises a lot of questions about who would feel comfortable providing a bond, posting a bond for him in this kind of circumstance.